Before we dive into today's captivating topic, I want to take a moment to remind you to show some love and support by liking this video, subscribing to our channel, and leaving a thoughtful comment below. Your engagement means the world to us and helps us bring you more intriguing content. All right, let's get into it. Today we're delving into the fascinating world of affirmative action in education. And what better way to start than by discussing a recent landmark ruling that has sent shockwaves through the academic community. We're talking about the University of North Carolina and Harvard Supreme Court ruling. But before we explore the specifics of this ruling, let's take a step back and understand the historical context of affirmative action in education. Affirmative action refers to policies and practices aimed at increasing opportunities for historically marginalized groups, such as racial and ethnic minorities, women, and individuals with disabilities. Our tale begins in the early 20th century, where the seeds of affirmative action were sown. In 1941, President Franklin D. Roosevelt issued Executive Order 8802, a powerful step towards combating segregation. This order mandated defense contractors to provide equal employment opportunities without any discrimination based on race, creed, color, or national origin. A giant leap forward. In 1961, President John F. Kennedy signed Executive Order 10925, marking the first use of the phrase affirmative action. This order required federal contractors to take proactive measures to ensure equal treatment in employment, regardless of race, creed, color, or national origin. After Kennedy's tragic assassination, President Lyndon B. Johnson further solidified affirmative action with the landmark Civil Rights Act of 1964, which prohibited segregation and employment discrimination. This act outlawed segregation in public spaces and employment discrimination, creating the Equal Employment Opportunity Commission, EEOC, to enforce these laws. In 1965, President Johnson issued Executive Order 11246, expanding affirmative action policies to federal contractors and subcontractors, covering areas like hiring, firing, training, and recruitment. This bold move expanded the scope of affirmative action, protecting employees from discriminatory practices based on race, color, religion, and national origin. And over time, it evolved to include safeguards against discrimination based on sex, sexual orientation, and gender identity. However, affirmative action has not been without its challenges. In the 1978 Supreme Court case, Regents of the University of California v. Bakke, the court found that the use of racial quotas in admissions was unconstitutional. Nevertheless, the court acknowledged the importance of diversity in education and allowed race to be considered as a factor in admissions decisions. Fast forward to recent years, and we find ourselves confronted with the Harvard ruling. On June 29, 2023, the U.S. Supreme Court ruled that affirmative action programs at Harvard and the University of North Carolina were unconstitutional. The court argued that race-conscious policies violated the Equal Protection Clause of the 14th Amendment. The ruling was issued by the U.S. Supreme Court and had a vote of 6-3, with 6 conservative justices forming the majority and 3 liberal justices in dissent. Chief Justice John G. Roberts, Jr. wrote the majority opinion, while Justice Sonia Sotomayor issued a dissenting opinion. This ruling is expected to have significant implications for Harvard's admissions process and may influence how colleges and universities across the nation approach diversity. While Harvard expressed its intention to comply with the ruling, specific changes to its admissions process have not been disclosed. Yet it doesn't end with Harvard. The ruling also extended its influence to the University of North Carolina and beyond. The decision may lead to a shift in considering race as a factor in admissions, potentially reducing its role, but still allowing for the consideration of an applicant's discussion on how race affected their life. It's important to note that the full details and long-term effects of the Harvard ruling are still unfolding, as institutions like Harvard determine how to adjust their admissions practices in compliance with the Supreme Court's decision. And that wraps up our exploration of affirmative action in education, culminating in the thought-provoking Harvard ruling. We hope this discussion has shed light on the history, challenges, and current developments surrounding this important topic. Once again, we appreciate your support and engagement. Remember to like this video, subscribe to our channel for more enlightening content, and leave a comment sharing your thoughts and experiences. Until next time, Keep seeking knowledge and questioning the world around you. Stay curious. This is Bite-Sized Politics signing off.